dulu. Okay, let's take a look at topic 13. Today we're going to cover two topics, topic 13 and 14. Can you see my slides?
Yes, sir.
Okay. Okay, electronic commerce is another topic that is very important in the discussion of information technology law because of the number or the amount of contracts that were entered into by electronic means. So we can see that because of the advance of the internet as well as all this online banking, there's a lot of internet or electronic activity, and we are doing this every day. Some of these discussions may be linked to contracts, what you have learned in contract, but we will try to see the development in as far as the E-Commerce Act is concerned, and we will also look at issues on formation of online contract. How the formation of online contract would be different from the one in Contracts Act. So this one is formation of online contract recognized under the E-Commerce Act, and then from there we will see online agreements like ClickWrap, ClickWrap agreements. If you have seen online agreement, can all the materials are being made in the form of soft copy lah, that you can see soft copy, and then you can click directly whether you agree or not with the terms and condition. Sometimes we purchase software, and then we want to install a software. So the first thing that they show to you is the agreement. So that is ClickWrap or BrowseWrap agreement. We look into that and what would be the legal implication, whether BrowseWrap or ClickWrap agreement is similar to the ordinary contract. And then we'll look at sometimes or most of the times internet users don't really read online terms and conditions. They just scroll and then they click accept, whether that action absolve whether he is, by doing that, whether he is actually bound by the contract that he didn't, terms and condition that he didn't really read. A lot of people do this, isn't it? I mean, they ask you to read, but then you scroll, and then later on you discovered that there were certain terms which is not favorable to you, and then there are cases actually to say that they try to argue before the court that these terms are not binding on them because the service provider didn't bring this to their attention, especially like credit card products. They give you product disclosure sheet, PDS, product disclosure sheet, which has the summary of all the terms and condition. So at the same time, they also give you the link to the full terms and condition of the agreement, but seldom that people read the full terms and conditions, so they just go through the product disclosure sheet, and that's just a summary. And later on, they found that there was something else which were not brought to their attention. So we look into these issues. And then we'll also finally we will look at the development of digital signature, digital signature, whereby we have the Digital Signature Act, and then what is the difference between the ordinary electronic signature as opposed to a digital signature. So legally it has a difference. Not all contracts, online contracts, require digital signature, right? Okay, so this one, we have the Contract Act 1950. However, as you have learned, it does not provide for modern forms of electronic communication, such as email or e-contracting through the web. So even the Contract Act has not been revised for so long already. So you have been learning the basic law of contract, but when we want to link the certain principles with what happens in the online world, then we have some limitation, because the Contract Act doesn't spell out anything, except even instantaneous communication was not spelled out. It was developed through cases, and then Malaysian, we have in 2006, the Parliament passed the Electronic Commerce Act, or the E-Commerce Act. So this basically recognize contracts entered into by electronic means. So this act is applicable to matters concerning commercial transaction, but it does not apply to family dispute or to support the admissibility of instant messages in family dispute. So this one is purely commercial. So this is just to show to you what does it mean by commercial transaction. In section 2, it is defined as single communication or multiple communication of a commercial nature, whether contractual or not. Sometimes it is a commercial communication, but not necessarily people will enter into contract. And this includes exchange of goods and services, agency, investment, financial banking, and insurance. Okay, and then section 7 talks about formation of contract. Actually, the formation of contract is similar. Similar with the what you have learned in contract law last time. But section 7 is specifically saying that the contract shall not be denied legal effect only on the ground that it is done through electronic message. So it means that section 7 specifically recognize online formation of contract. So offer acceptance done online, recognized clearly by section 7. Section 8 talks about where any law require information to be in writing, so express in writing. Then when you use electronic message, it means that this requirement for the contract to be done in writing is fulfilled. So the section 8 ni dia macam it clears up the suspicion that sometimes people think when a contract has to be in writing, it means that it has to be printed, it has to be written like on a paper. But section 8 is expanding that interpretation. It is saying that if you use electronic message, including SMS, as decided in the case down here, Yam Kong, so it means that even concluded through SMS or even WhatsApp, Facebook message, section 8 recognize this as a contract in writing. Section 20 talks about time of dispatch, meaning when you make the offer, the electronic message comes out of your computer. So that unless otherwise agreed, then the time when the offer was made is the time when your email leaves your computer. Usually we can detect this if we are sending email, offer by email, there's an automatic system that tracks the time when we send out the email. Time of receipt will be the time that is dedicated by the system, unless in your agreement you decide otherwise, then that would apply lah. Section 22 talks about place of dispatch, the business address and so on, place of receipt, sama lah, unless if you don't decide it in your agreement, it will be the address of your in a contract you have to determine the address of the contracting parties, isn't it? So it will be the address of the place of business. If the place of business is not available, it will be the residence lah. Okay, in this case, this was eBay International. So Federal Court of Australia had to consider when contract for sale and purchase of 2 online websites were concluded. When. So the court held that the contract was signed electronically by the purchaser upon clicking of the buttons, and then you make the payment, and when you receive the confirmation order, then meaning that the contract is completed. So the contract was signed and completed after the payment and nominated purchaser details were accepted lah. So if the payment is not yet complete, meaning the contract, the formation of contract is not yet complete lah. So otherwise, unless you agree otherwise, this is for online website. If you are doing it through a live website, so the court had to consider, okay, if you're buying a flight ticket, you can't be using a principle similar to engaging a contract by email. Email might take some time, but on this note, in the issue of acceptance, offer and acceptance by email, you have learned before this that if you using letter or fax, that the postal rule would apply. But as decided in recent cases, like Thomas BPA solicitor, email, SMS ke apa ni, all these are instantaneous technology. So meaning you have to apply instantaneous communication. It means that communication of acceptance is not effective until it is being communicated to the offeror. So both offeror or offeree has to acknowledge the offer and acceptance. Unlike the postal rule, not necessarily the other side has to effectively acknowledge about a certain that he has accepted the offer kan. Kadang-kadang macam the letter is lost halfway pun, there has been cases to say that the contract has been binding already. So on this note, we take note that postal rule does not apply as far as online contracting is concerned. Okay, although in some cases it might not be so straightforward, so the court will have to see the cases, the facts one by one, what would be the intention of the parties, and then have to cross-check that with sound business practice. Then only the court will be able to determine at which point the contract has been concluded. Okay, agreements which are based on electronic communications, they are valid agreements. Example here is case of CLR International here. Agreements based on electronic communications such as emails and fax, they are enforceable and they form a contract. This is also in line with Section 2E of the Contracts Act. Of course, if we refer to the E-Commerce Act, this is further supported by the E-Commerce Act. What about formation of contract via instant messaging apps, WhatsApp and so on? So it has been decided in these cases, Lim Chow Ho, for example, Shamsuddin, a contract can be formed or proven through messages originating from instant messaging applications. So the court will have to determine whether there is a contract concluded between the parties. The court will have to see the facts, whether there is a definite offer made by one party, and then whether the other party has accepted. So the court has to dig further lah, on this. The court may also look into the documents relied on that constituted the contract, and the court can see what would be their true construction, to determine whether there is an offer and acceptance lah. So sama lah, maknanya the position is similar to the regular contract. You can also make contract through WhatsApp messages. The position of what about the terms and condition located in the website, but it is not fully reproduced in the contract. This is what I talked about earlier on, that usually in advertisements, you can find online advertisements. If you go to maybe AirAsia website, the whole terms are not reproduced in the advertisement. You have to click on a certain link, then only you will know what would be the full terms and condition. So now, when the thing is that some businesses, they just use QR codes. They use QR code. If you scan the QR code, then only you will know what would be the term and condition. So most consumers, they don't like to open up this link. They just click accept. So now what would be the situation? Whether the terms and conditions are deemed to have been read and accepted by the consumer. There are several cases which has illustrated this particular point. Wong Wei Pin and Malayan Banking. This was actually between consumer and the bank. This Maybank, they have this credit card subscription. So the defendant the plaintiff has taken up the subscription on a personal account. It's for personal use, not for business use. So these Maybank, they have this trip points. They call it trip points, or a kind of a points that you can collect once you use. So you can collect points. So they call it trip points. So the thing is that this, because it's for personal use, meaning that there are certain the bank is not expecting a personal use to be to be too much lah. Maknanya you're using that too much. So the defendant here, they have used the credit card, and then now the plaintiff he or she is claiming for the trip points that amounts to almost 500,000. So plaintiff is now claiming for the trip point that valued at about 500,000. So now the defendant got they got concerned about this amount. So now defendant is thinking this is not for personal use anymore, then there might be a breach of the credit card agreement. So the defendant cancel the plaintiff's credit card, and then when the defendant canceled the credit card, plaintiff now sued for the trip points that were valued at 500,000. So now defendant further counterclaim that this amount 491,000 being the value of the trip points has already been redeemed by the plaintiff. And then the matter went up to Sessions Court. The issue here is that the plaintiff is trying to say that she was given this product disclosure sheet, and then she was not explained the terms and condition of the credit card. this actually links to the issue of the usage of the card was supposed to be for personal use only. Yeah. So of course the bank can terminate your card at any time if they found that there's a breach of the use, the use of the card lah. So the plaintiff is saying she did not know about the terms and condition that this cannot be done and so on lah. So the defendant is saying, well, the terms are provided in the full terms are provided in the maybank.com.my. The customer can also contact the card center to know more. But here the plaintiff is arguing the product disclosure sheet did not tell her the full information about the terms and condition lah. So here the court had to decide whether the terms and condition was effective and therefore binding on the plaintiff, and the High Court has decided that the plaintiff was bound by the terms found on the defendant's website. Yeah, even if the plaintiff chose not to read them, yeah, she was bound by them by the usage of her card and by the card. Yeah. So it means that when you the situation now is if you don't even bother to read the terms and condition, but you continue to use it, so they will assume that you have accepted the terms, and therefore you are bound, even though you didn't read the full terms. Yeah, that was the decision. Yeah. So that is it for meaning that even if someone didn't really read the full agreement, but they just read the summary of the agreement, the one that binds them is the full agreement, not the summary of the agreement. Yeah? So, and then next is on ClickWrap and BrowseWrap agreement. Yeah? ClickWrap, BrowseWrap agreement, this one is an online contract that was they're using ClickWrap ni macam ni rupa dia. So I think you have seen this a lot in online software. Yeah, BrowseWrap agreement is where it is done through website. Dia macam website lah. You open up a website, scroll, and then down there's a button. You have to click accept and whatnot lah. Okay, so this is also not so new, but we are seeing this a lot. And then there's also sometimes this is not the full agreement even. The full agreement is being, down there there's a link. If you click that, then it will link you to the full agreement. So this is also valid, yeah? Meaning that ClickWrap, BrowseWrap ni pun is valid, and most online merchants are using this. Yeah. Okay, on the writing and signing requirements for online contract, while there is generally no legal requirement that a contract must be in writing for it to be valid, yeah, but some contracts require it to be in writing and signed. Yeah, if you don't sign, then the document is inadmissible or the contract might be void. Yeah, so in this kind of, if your contract require written signature, then maknanya kena buat lah, the must have. Yeah, okay. For BrowseWrap, BrowseWrap agreement has terms and condition located on another page. Yeah, so this usually in the form of website lah, macam website. There is currently no reported case in Malaysia regarding the validity of ClickWrap and BrowseWrap agreement, but we can see that when so far there's no issue or reported cases to say that BrowseWrap not valid. Yeah. Nevertheless, the ClickWrap agreement should bind a party, so long as they indicated their acceptance. So if you go through a ClickWrap agreement and then you click the I agree button, regardless of whether you read the agreement or not, then the agreement is binding on you. And you can refer to Polygram Record, the case 1994. Although this is the situation, at the same time, the party should have sufficient notice of the agreement as well. This is also another precedent that the court tried to develop. Yeah. So if you, for example, if you click on a agree button tu, there has to be sufficient notice. Maknanya the website owner tu must provide sufficient notice about the where the full terms and condition can be read. So if you go and if you want to go and purchase an AirAsia ticket, at the link, at the button agree, there should be also sufficient graphic ataupun wording to say you click here to read the full agreement. So that if that is the situation, the customer still choose not to read the full agreement, then they cannot blame anyone else lah for not reading the agreement. Yeah. Just the case of Ragindran and AirAsia X. This concerns a customer who lost his luggage. Yeah, so he was on his flight. There's a transfer flight from Penang to KL and then to Melbourne. So the flight, the luggage was lost lah on the way. So the thing here is that defendant tried to offer, the AirAsia tried to offer compensation to the plaintiff based on the tariff set at USD 20 per kilogram. But the plaintiff rejected this tariff and claimed exact amount of 11,700 for the loss of his stuff. So now the defendant is arguing that they are actually, the plaintiff is bound by the terms and condition of this so-called tariff. Malaysia is also a signatory to the Warsaw Convention, and the Montreal Convention, which these conventions was adopted by our Malaysian Carriage by Air Act. Yeah. So because of these conventions, the liability of the aviation carrier or the AirAsia they are limited to a certain amount. Maknanya dia bukannya because of this adoption of these conventions on the act, any aviation carrier, you can claim compensation against them, but they are set, there are a certain cap in cases of death, injury or loss of luggage. So maknanya tak boleh simply kata aku tak kira lah, aku nak claim juga 1 juta 2 juta, cannot. So that the claims or the compensations are guided by these conventions. Plaintiff, however, claimed that he was not bound by the defendant's terms and condition because terms and condition were not brought to his attention at the time of purchase. So this is what he said lah. Number 2, terms and condition were only applicable to his domestic flight in KL, but not to his international flight. Defendant has caused the loss of his luggage, and the total compensation offered was a lot lower than what he had lost. So here, when during the trial the website of the AirAsia was examined by the court. So here the court found out that basically the terms and condition of the carriage was put in red notice. If you click that, the website would direct the user to another page displaying the terms and condition of the flight, because the plaintiff is trying to say it was not brought to his attention when he wanted to buy the ticket. So the magistrate held that it would be reasonable for the defendant to expect any person purchasing an airline ticket to know about the terms and condition of the flight. The magistrate also found that defendant had given sufficient notice on its website by putting a notice next to the purchase button with a red hyperlink. So if you click that red hyperlink, it will go to the terms and condition, and the contract is formed as soon as the payment is made. And any terms and condition of the flight would bind the parties as soon as the contract is made. So in this situation, the plaintiff's claim was dismissed. Yeah, court found that there was a contract between them, although the plaintiff didn't really read. Yeah? But in this case, maknanya plaintiff lost lah. Plaintiff lost his claim against AirAsia, but the plaintiff has appealed the matter to Penang High Court. Yeah? So far, has yet to hear any update on this. Yeah? Kalau ada soalan, just interrupt me as I go along. What about terms and condition provided via hyperlinks? Yeah. So of course, as we can see in the previous case, this is a valid way. Yeah, this is a valid way to provide the terms. And however, the situation is that okay, you can provide the hyperlink. Yeah, maknanya terms and condition tu is attached using a hyperlink. But as decided in cases like AirAsia X just now, the court will have to see whether this hyperlink is people can sufficiently notice this hyperlink. Kadang-kadang hyperlink tu tersorok dekat bawah-bawah kecil-kecil kan, you cannot see, isn't it? But if the court found that this hyperlink is sufficiently noticeable, maybe like the case AirAsia X just now, it is being put under the purchase button with a red font, then the court might find that okay, this is reasonable notice. If you didn't click this, meaning it's your fault lah. So English law has been consistent with Malaysian law on this. The court will have to see whether a party had taken reasonable steps to ensure that the terms and condition had been brought to the attention of the other side. Yeah. So these two cases are saying that this case and this case, it's about they contracted, and in the contract they have these terms to say that English law shall become the law that if any disputes happen, they will follow English law. So both are actually from different jurisdictions. So there is this dispute lah about which law will apply. Yeah, I think we find this a lot. If you just cross-refer to social media, Facebook, for example, you can find in the terms and condition that says if you continued use of the service, the social media service constitutes acceptance of the terms and condition of Facebook. Maknanya you continue to use all those social media. Maknanya you are, although you didn't sign anything, you didn't even click on any button that says accept ke apa, you use it, means you are bound. There is also terms and condition that says you are bound by which law. And if there are disputes, which law will we refer to? So kalau macam social media Facebook, you can find terms that says you will have to try to settle the matter first in your own jurisdiction. If that didn't work out, then the law that you will have to refer to will be the US law. So Dokbil might argue, I'm not bound by US law, tapi by the agreement, if you wanna, you have signed the agreement and you want to settle the disputes with them, maknanya you have to follow what the agreement has said lah. So here, the court decided in this case that sufficient notice was reasonably given by the party. Yeah. So this the position of Malaysian law is also similar. The court will inquire, yeah, kalau if anyone use hyperlinks, yeah, to maknanya they use hyperlink, and you need to click on the hyperlink to show the full terms and condition. This particular criteria applies, yeah. So there must be a clear and concise notice that informing the reader that their hyperlinked contract or terms apply. Yeah. So kadang-kadang orang macam dalam kes ni kan, Able Food ni, this is where in the contract it was between Malaysian company and a New Zealand company, and then in their contract too, the New Zealand company said that if any disputes happen, New Zealand terms and conditions or the New Zealand law apply. So they didn't. I mean, the full term was not spelled out in the contract, but they just put it like this in the form of hyperlink. Please be informed that we have revised the terms. Please look at the link. Yeah. So actually, in this case, yeah, they have actually before the dispute too, they have entered into 7 sales contract. Yeah. So in this case, when the matter was referred to Court of Appeal, Court of Appeal found that the parties had several cause of dealing already. So now the plaintiff cannot say that they don't know about the term of the contract because they have been dealing with each other. How can they not know that New Zealand law binds them? Something like that. Yeah. So now here it is clearly stated in the terms, yeah, that the parties agreed to comply with the term, and although the full contract is being put in the link, hyperlink, the court thinks that it is the duty of the plaintiff to look up for the terms because the hyperlink has been provided. So bila the plaintiff didn't bother to visit the hyperlink when the changes to the terms has been notified, yeah. So this is a failure on the part of the plaintiff, yeah, to check, yeah, and to read the terms and condition. So this can also be linked to unilateral mistakes, the issue of unilateral mistakes in online contracts. So we have learned about this in the last time. Unilateral mistake will not invalidate the contract. Yeah. So in online contracting pun sama, yeah, the situation is the same. But if it depends because mistake has some criteria. Okay? If the mistake was it goes to the core of the contract, yeah, so much so that the contract is no longer beneficial for both parties, then the contract can be declared as void. So in a way, the mistake is no longer unilateral; it becomes a bilateral mistake. And in this case, Chi Kin Kiong, this was about selling of printer. So this Singaporean country was selling printer, yeah. And then the thing was that there was a mistake in the advertisement. The advertisement said that they mistakenly advertised the price so much lower. So when the buyer they found out about this offer, they buy a lot, about 4,000 printers they order. And then later defendant discovered that there was a mistake on their own website. So they sent an email to the complainant saying, or to the plaintiff, saying that they will not be fulfilling this order because there was a mistake done as far as the pricing is concerned. So the matter was referred to court. Complainant argued that they were not aware that this price was a mistake, and then they want the contract to be fulfilled. but the defendant is arguing that the price was a unilateral mistake and the complainant took advantage of this. And the issue here was whether the contract is valid and should be fulfilled. But the court here held that there was a binding contract between the parties. Yes, there was a binding contract, but the contract was void because of mistake which was fundamental to the contract. Yeah, and complainant in this case was the court basically say that complainant must have known that this was absurdly low pricing, was an error by the defendant. In this case, there's also no consensus ad idem, or the meeting of the mind. There's no meeting of the mind between the parties. So the court said that the contract was void. Yeah, the contract was not binding. Yeah. So though this was the complainant might felt this is not fair for me, but again, if the matter was not referred to the court, then in the first place, there is a contract. You know, contract tu ada. But if you want to invalidate the contract, then tu yang the role of the court comes into play lah. Yeah. Okay, so that is about online contracting. So now we want to talk about electronic and digital signatures. Yeah. E-Commerce Act Section 5 defines electronic signature. Yeah, it means any letters, character, number, sound, or any symbol. Yeah, maknanya any sort of symbol can become a signature lah. Yeah, it is a valid signature. Section 9 talks about where any law require a signature of a person. Yeah, the requirement of the law is fulfilled if the document is in the form of electronic message. Yeah, so valid lah if macam you sign attendance through the online form that I give you. So you take macam tu that is electronic signature of yourself lah. Yeah. What about formality, validity, and admissibility? Yeah, so formality may be required under statute or statutory instrument. Yeah, so some examples of formality. Yeah, that some agreement require that the signature to be witnessed. There has to be a witness of the signature, and then some documents or online contracting they require specified form. Maknanya if you want it to be handwritten, then you cannot use online kan. And electronic signature is admissible as an evidence in legal proceeding under Section 90A of the Evidence Act. Yeah? So if you use electronic signature for a particular legal document, this electronic signature alone is a valid signature to be used for purposes of legal proceeding under Section 90A of the Evidence Act, to prove or disprove identity of the signatory, to prove the signatory's intention, to authenticate the document. So bolehlah, maknanya electronic signature is a valid, it is a valid piece of evidence. Yeah. The court have also held that these things are to form a valid signature. If you sign with X, sign with initials, use a stamp of a handwritten signature. Kan ada orang macam dia tak sign betul-betul tapi dia chop dia punya signature kan. That is also valid under the law. Signing with a mark, a description of signatory if sufficiently unambiguous. Maybe you just put, you didn't sign properly tapi you tulis tu with love, macam tu je you tulis kan. That is also, if it's not too unambiguous, then it can be accepted. Yeah. We also have another one which is Digital Signature Act 1997. So what is the difference between this digital signature and electronic signature? Yeah. So digital signature, this one, it is basically a unique kind of encryption requirement lah, what we can say lah. That if you use digital signature, it offer higher security and protection from fraud than other types of electronic signature. So this is not a simple sign tau. Dia ni macam you're using a kind of a encryption key in order to sign a particular or approve a particular document. Katalah macam a company, they decided to have this digital signature system. So the CEO has the authority to approve any agreements, sign any agreements or approve any particular thing relating to transactions of the company. So the encryption key is given to the CEO to approve things lah, and it is only him who can open up and use the encryption key. So only with this encryption key, then the decryption can happen. So this is actually, they call this as asymmetric crypto system. So senang nak cakap, dia macam satu special kind of password lah that is created for a higher level of security. And then if let's say if whatever that you want to do, katalah your agreement, you would like to apply the requirement of Digital Signature Act, then the law will require the application of all this requirement lah. So example, maybe we're talking about banking system where a higher level of security is required. So the manager, only the manager can accept the particular agreement or whatnot. So maknanya the requirement of all this security requirement under digital signature must be fulfilled. Does a simple contract require digital signature that complies with Digital Signature Act? No, no. Simple contract does not require a digital signature that comply with Digital Signature Act. So sebenarnya digital signature yang comply with Digital Signature Act ni, meaning it has to be cryptography encryption system like this lah. They have to use this kind of complicated security system in order to approve a document in order to open up a document. So basic contract does not require this. Tapi certain kind of industry may require that, and if they require that, they have to comply with the security requirement of having encryptions to be part of their process lah. So the key difference between Digital Signature Act and Electronic Commerce Act can be seen by referring to the opening sentences. DSA, Digital Signature Act, provide that requirement of a signature can be fulfilled by way of a digital signature under the DSA if a rule of law require a signature provides a certain consequences in the absence of a signature. But in the ECA, Electronic Commerce Act, if you just use, you just sign, there is no effect, no consequences. If you don't use. Dia kata ECA is applicable to any law that require a signature of a person on a document, and there are if there is no signature in that document. No, maknanya dekat sini it applies to different sets of interest lah. If you are in a banking sector, for example, you require a higher level of security. Then you at the same time, the banks, for example, they are bound by certain regulations that they need a higher level of security, for example. So they have to use digital signature, because if they don't use digital signature, which has all this encryption and whatnot, then they might be in breach of certain requirement, compromising certain set of security regulations. So maknanya kalau dia tak guna tu ada some implication to them. So in that particular industry, they have to use it, and then they are bound lah by all the requirements of the Digital Signature Act. But other kind of simple agreements that do not need this kind of thing, so they don't have to apply Digital Signature Act. They can just use Electronic Commerce Act, or maybe even the Contract Act lah. Maknanya tak payah pakai digital signature ni, bukannya wajib pun nak pakai. But tapi as far as validity of the agreement itself, simple contract, if you just use Electronic Commerce Act, just sign whatever symbol that you like, can also validate the contract. Yeah. Okay. Okay, this one I have explained just now. With respect, under Contract Act. Contract Act does not provide for the requirement of a signature in contract. Tak ada tau. So in Contract Act, if you try to find whether we need a signature to validate a contract, this one tak ada. But under E-Commerce Act, yes, they have this lah. Okay, so we have come to the end of this topic. If we go through in summary, online contracting by way of SMS, by way of WhatsApp, on even websites, they have been recognized by the law as valid. And as far as the terms and conditions are concerned, generally all users are expected to know the terms and condition, and but on the part of the seller or the service provider, they have to act in good faith as well, especially when the terms and conditions are hidden in hyperlinks. They have to at least bring the link as so far as it can be noticeable to the customer. So that would be the part of the court to interpret how reasonable is the notice. And then when we want to conclude a contract, then the issue of signature comes in. For a simple contract that requires offer acceptance too, digital signature is not a requirement. You can just use E-Commerce Act, meaning you can just sign. If you want to use X ke any symbol you can use, and that can validate the contract lah. Tapi in certain kind of businesses or maybe industry, they require a special kind of password or higher level of security, so they cannot just use simple signature that just anyone can make. Kan nanti kalau you're talking about $billion contract, kan, katalah someone hacked into the system, then the company has to be bound by a contract that they did not do. So which is why in this kind of situation, they require a higher level of security. So if that is the case, Digital Signature Act will apply, and they have to do all that encryption kind of system, so that only authorized persons can approve and sign the contract lah. Okay, any question on this? Okay, if there's no further question, let's just go through the last topic. This is just a short topic on online dispute resolution. So when we know, when we, kejap saya share screen dulu. Can you see topic 14 here?
Yes, sir.
Okay. Online dispute resolution is we can see that this is similar to alternative dispute resolution lah. Yeah, even in online environment, disputes happen, and we know that courts are the common. It is the common platform that is being referred to whenever there is online dispute. But new way of resolving disputes has also emerged in the form of ODR, online dispute resolution, which is pretty similar to alternative dispute resolution, but when the parties are from different jurisdictions, this particular medium is very useful, especially when they are disputing over commercial issues, yeah. Whereby they can apply arbitration or ADR and mediation and so on, but these were done fully online, sometimes by full use of email or even the web-based technology and so on, yeah. So this ODR is carried out by combination of online technology as well as automated. If we use, for example, eBay. eBay has this example of ODR model. Yeah, it was said that they are able to resolve almost 60 million disagreements among the traders each year. At the moment in Malaysia, although I'm not really saying that we don't have, but if we see Shopee, for example, Shopee ke Lazada ke, they have started to have this sort of ODR mechanism. They try to resolve the consumer's dispute, but we can see that if, for example, Shopee can, they put the terms of the dispute clearly, so that dia beritahu siap-siap lah, if let's say within certain date you didn't click this button, then we will cancel this thing for you. Maknanya the terms are being negotiated, not really negotiated, but dia macam the settlement is happening through a proper process. But if you're not happy with this, then meaning you have to lodge a complaint, and then they will go and investigate, and perhaps a proper ODR sessions has to be conducted lah. Okay. I don't want to talk about these two model legislations. They are you can just check this out briefly. OECD, there are two models in a way that these models were developed to ensure fair business practice. Yeah, models of ni lah, ODR ni. This is basically just a guideline. They are just guideline, and countries have been referring lah to the guideline, but they are just merely self-regulation guideline. So ada yang mana they are not really binding on states to follow. Yeah. But just to share to you some models of ODR. This is online mediation, CyberSettle. They try to do this. There are many companies, private companies, that do this online mediation service. As far as our own Malaysian Mediation Center, I believe that, as far as I know, they don't have online mediation. They may have online sessions because of the pandemic, but again, people would prefer to go and meet face to face rather than just online lah. Sebab lagi yalah, people are more comfortable to, if they want to shout, they shout lah in front of each other's face online kan. I mean face to face. So maybe due to the pandemic, they might have online sessions, but most of what we know now is that disputes are being resolved through face to face mediation lah. Cybersector is one of a website that is doing this in the US. Yeah, they are quite established. Ada banyak lagi lah websites that you can check out. But most of them these are based in US. Tapi in Malaysia, dispute resolution yang established ni, the one that is managed by Malaysian Mediation Centre, even AIAC, or the former name was KLRCA. AIAC nama penuh dia apa? ASEAN International Arbitration Centre. It is situated at dekat kereta api, stesen kereta api Kuala Lumpur tu. If you have the opportunity to visit that place, maybe you participate in arbitration competitions, then you may actually go there to, you know, just to learn lah, to be exposed to arbitration and so on. So we have that. I mean that those are they are the big ones lah in Malaysia. AIAC. People who have issues and they want to resort to arbitration, they can go and find an arbitrator in that particular institution. Cumanya the institution again is not really online. Meaning the sessions are not done online. I haven't seen lah, tak pernah jumpa lagi whether they are shifting to online disputes resolution soon. But I believe because of the technology and so on, this is I think it is possible to be done. I guess it depends on the parties. If the parties are okay to have online sessions, then they should be able to facilitate. There has also been this development of our courts, whereby the courts have been doing online mediation as well, where they do this in the court mediation center. So this is happening in courts. I'm just showing you this is in Malay because I found this piece of infographic and it is written in Malay. So this is the process of mediation. Although it is done online, but you can see that the processes are there, and if people want to go through, if they want to settle their disputes, not through courts, but it is a court mediated dispute lah. So before mediation, you have to fill up some forms, and then the mediator will be appointed, and then the parties will have to send all these documents to the court online by email, and then they will. Oops, there are people waiting in the lobby. Okay. And then during the mediation, the mediator can schedule a Skype or Zoom call, Google ke apa, and then they have to ensure internet is stable and so on. Apa lagi? Meaning that these are online. I mean the federal court or the judiciary has this process in place already. And then after the mediation is done, for cases that can reach a settlement, the lawyer will have to send a draft order, a draft perintah, draft order, which has been agreed by both parties, signed by the lawyer, and then the court will issue an order, and this can be sent by email. So cases which has failed to reach settlement, meaning you have to go to the trial. You have to go to the trial. So maknanya this is a model, a Malaysian model, a working Malaysian model already. Okay, I think this is good. As far as the development of technology is concerned, we are now having virtual courts. Even the court of the statutes, if I'm not mistaken, the Court of Judicature Act, for example, if I'm mistaken, has also been there has been provision to allow virtual hearing. And hopefully we will see a lot a lot of other developments as far as this technology and court is concerned. Yeah? Okay, any questions? Short topic, but important. You can actually, you try to link this discussion with, if let's say you have a problem in your answering your final exam question, there might be some questions asking about what would be the legal solution. ODR is one of the legal solution that you can discuss. Yeah? Okay, any question?